suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Time for your real good lawyer. David Whiting is here, well-known Melbourne solicitor, helping you with legal problems, and you're all fine. No one has a problem because I've got 3 callers waiting and all the other lines is free, which means that everyone is doing the right thing in Melbourne and around Australia right now, which is tremendous, David.
Oh, it's fantastic.
Isn't that great?
I think everyone's home. I'm walking through town today. It's just quiet.
It's empty, is it?
Yeah.
Yeah, the message has gone
Yesterday
out. Work
was
from
busy,
home.
but today is, yeah.
Oh, well, that's good. That means I can get things done in the city when I go home because no one will be there, so I can move more expeditiously.
Yeah, let's not get carried away.
No, okay, all right.
Easier rather than easy. Yes.
All right. Well, look, I'm handing you the golden ticket this morning because the lines are free and you know how hard it is to get through. Grab them right now, 1300 222 774. Oh, people are flying in as I speak. So last chance because you know how hard it is to get this rolled gold advice from David Whiting. Do we have any homework?
We do. We have Greg from Hurstbridge.
Ah.
Greg lives in a 2-unit development and he can't get any cooperation from his co-owner. They refuses to attend a meeting, refuses to do a whole series of things in relation to what Greg thinks is important for the development. What can he do? And the answer is almost nothing.
Oh, great.
If you look at the provisions of the Owners Corporation Act, there are so many provisions that just do not apply to an owners corporation with 2 units. The insurance provisions don't apply, the meeting provisions don't apply, the financial records provisions don't apply.
Why?
I think it's the expectation is that
you'll figure it out amongst yourselves.
Figure it out amongst yourself. The other issue, of course, is that you can never pass a resolution because it's always a yes and a no.
Yes, right.
And you need two people for quorum. So you and I have an owners corporation together. I call a meeting. You don't turn up. We can't do anything. So it's the expectation.
I would say in a grouping of 2,
yes,
1 would be quorum. Wouldn't you say?
Well, one might think so, except I'm quite sure that you would respond with a meeting at the world's most inconvenient time for me, and you would pass your resolutions.
Why are people so annoying? Honestly.
Yeah, I think, look, my view is that the 2 owners should have an interest in making their units as good as possible. So
it's their key investment.
So the only thing from Greg's point of view is to endeavour to generate a default by the neighbour of the model rules and take them to VCAT. But that's just more time and effort.
And that's the only advice you got right here, VCAT?
Yep. Even the complaints process in the Owners Corporation rules doesn't apply. Because who are you going to complain to?
You know how much of a fan of VCAT I am.
Well, can I say, I last year I asked VCATs for some stats as to how they were going in COVID, and I picked up some interesting information. When COVID hit us in March 2020, they were entirely paper-based, had no electronic records but no electronic filing system. It took till October, and they have 200 members. So imagine a court that's got 200 judicial officers. It took till October till they were given the funding to get computers that would enable them to have Zoom meetings.
Yep.
But they're also, and in the last 18 months, they've concentrated on compensation claims and guardianship claims. So their backlog is reduced substantially. So am I the greatest fan? No. But it's a tough gig and they're doing better.
1300 222 774. Speaking of VCAT, Angela in West Melbourne, go ahead.
Thank you. David, thanks for taking my call. On the 28th of April of this year, the chairperson and myself, I'm a committee member of this particular Owners Corporation Committee, submitted an application to VCAT for compensation for what we saw as inefficient handling of our property
by a property manager.
By a property manager.
Yes.
And of course, finally in August of 2020, we did move. But what happened in June of this year, we had our directions hearing. Now, prior to that directions hearing that happened on, I think it was the 6th of June, in mid-May, after we had sent out the documents to VCAT and to the Owners Corporation manager, we received an offer from the Owners Corporation legal team.
Yes.
And we ignored it because we were going to go to VCAT because it was not a sufficient amount in our view.
Yep.
When we got to the meeting, their solicitor said that the respondent had in fact not received the documents. We had all the evidence to show that the documents had been sent to VCAT and to the respondent.
To the other side, yes.
And that in fact it had been picked up because it was signed for. Subsequently, I was a bit annoyed and I thought, well, this isn't right. You know, their statement at the hearing that the respondent hadn't received the documents was untrue.
Angela, you've got to know. So where are we at?
We're at that. We're having a hearing next week.
Yes.
Now, the solicitor has prepared on the respondent's behalf their schedule.
Yes.
With documents. There are two schedules. One is a schedule with our documents.
Yes.
And the other one is their schedule of documents. Now, in the schedule for our documents, they have included the offer of settlement.
Angela, what you want to do, that matter, the offer should not be available to the member hearing your case. So you would write to the registrar of the Owners Corporation list today and you would ask for that document to be removed from the file.
Okay, good.
And you would, in the event that the matter has already been given to a member for consideration, ask that it be sent to another member. You might also copy the lawyer acting for the property manager into that, and you would also complain, I would have thought, that it's not a proper document to be included in the bundle for the resolution.
Okay. Well, good luck. We hope that actually works for you. Mick in Port Arlington, go ahead.
Hello, this is Mick. Before I start, great little intro to your segment, Virginia and David. Very, very pleasant, very pleasant.
Oh, well, I certainly love that music, so thank you.
Yeah, it's gorgeous.
I like the first bit.
An odd matter. My wife and I were driving down a street in Port Arlington on a wet day recently, and a Australia Post delivery person on a Australia Post little motor scooter came through a give way sign and hit the back door of our car.
Yes.
We then, approached Australia Post. Were told at the local post office to ring a number for Australia Post. Very, very early on, the woman who I spoke to said, "Oh, you've got to speak to the postman."
Where are we going, Mick? What's the issue now?
Because what's happened is that I then spoke to the person and she said she would deal with the matter and put it through to
So is the person driving the bike or somebody else?
No, it's the postman he's the postie, he's riding the bike, he's an Australia Post.
Yeah, I understand. So the answer is you have a claim against the person riding the bike, and you also have a claim against Australia Post on the basis that Australia Post is responsible for the actions of their employees.
Yeah, right. So what happened was that I gave the details to the woman with Australia Post.
Mick, where are we at now?
Well, I gave the details to the woman for Australia Post.
Yep, keep going.
Yeah, that's fine. She said the Australia Post would get back to me and detail me, and go further.
Well, Mick, we need to jump to the real nut of the question here. What advice do you want from David?
The next morning...
No, Mick,
contact from...
Mick, what's the last contact you had with Australia Post?
Yeah, where are we up to right now?
The first time I spoke to the woman...
No, the last time. What's the last time you spoke to somebody at Australia Post?
No, I didn't. Beyond that first call, I didn't speak to Australia.
Okay, it's been no contact.
You've had no communication at all?
Yep.
No. I spoke first off.
No, Mick. We're trying to build. We're trying to get to the centre of the question, not the background.
Yep.
There will be. The answer is you want to talk to complaints at Australia Post about an insurance issue. So there will be an email address, or you walk into a post office, you talk to a post manager about making an insurance claim against Australia Post. There will be a process. I would be extraordinarily delighted if they don't have a form, and they'll give you a number or an email address.
But there probably will be a form, Mick. We hope that's helpful.
There's a form for everything.
There is. Sharon in Sunbury, go ahead. Good morning.
Yes, good morning to you both. David, I'm trying to help a friend with her finances, updating her MyGov account prior to moving into aged care. She has an item in there listed, a trust, and it's preceded by a 9-digit number, then with a K at the end. I don't think she has that money anymore, but it's $28,000 and she could use it if it did exist
if it
somewhere.
Existed, yes.
I Googled it, which led me to the ABN lookup, and I found an entry for the trustee for the name of the trust.
Yes.
And it said that the ABN in relation to that had been cancelled in 2014.
Yes.
And it was a discretionary trading trust.
Yes.
But I'm just wondering, does that mean if the ABN was cancelled, would that mean that the money had been withdrawn from the trust, or do you think there is somebody else? Is it likely that there would be a trust sitting somewhere with the $28,000 in it? Or is there some way I can find that out?
I would have thought that would be unlikely. Does she remember how long she's had the money? Does she remember where she got it from?
She was running a business, and somebody got her to set up a trust, an accountant she knew.
So I would go back to the accountant.
Oh, it's not possible now, unfortunately. She's had a medical
all right,
situation,
Sharon,
and she wouldn't remember.
Sharon, I would be writing to each of the major banks, so I would be writing to the 5 of them, including Bendigo, and give them your friend's name and date of birth, and or even if she writes the letter, and she's looking for any information in relation to any accounts that she has at those banks. That's where I would go, and it may be that if your friend is well enough, you could take her into the banks and ask at the counter if she's got proof of identity like a driver's licence or a passport. And if there is no account, then just don't include it in the information you give to Centrelink.
Does that help?
Right, okay. So you don't think the trust would be existing anymore?
Well, the only way that it could be tracked back to your friend would be if she was a trustee. Now, that's quite possible. If she was in business before, she could be the trustee of the fund. You could spend a little bit more money and you could find out if there is a company of which she was a director, so you can do an ASIC search.
No, she only had her own. It was her own.
Just a little business,
counselling business. Yes,
yeah.
Yes.
Then that's where I would go.
What's the strongest evidence that it exists or not anymore, David? Is there any?
Well, the issue will be that Centrelink does data matching, and if they find an account with your name on it and you haven't told them, they get cross.
Right.
So you would start with so I'd go to if it's there, it'll be in a bank account.
Yep.
So I would be approaching the 5 major banks and saying, do you have an account in my name?
Okay. I hope that's helpful. Maddie in Colac, how can we help, Maddie?
Hello. I have a situation in my family. I'm the eldest child and I have 3 brothers. And our father has been estranged from us for a very long time, perhaps 50 years. And I'm just wondering, do we have any claim on his will? We're his only natural children.
Maddie, you are what's called an eligible person. So under the legislation, you have the right to make a claim.
Yes.
But that you would need to look at the relationship that each of you have had and why the relationship failed before I could even hazard a guess as to whether you or your brothers would be able to succeed in a claim against the estate. So it would be, one would say because he brought you into the world, he owes you something, but it's a needs-based jurisdiction. So it's an analysis of where you're at in your life and the other claims on his generosity. Now, you're an eligible person, but I can't for the life of me, wouldn't even like to hazard a guess, and you and your 3 brothers each have different claims. So,
I'm just speaking I'm speaking on behalf of them as well.
No, I understand that. I understand that. But the circumstances giving rise to your claim might be different to the circumstances giving rise to each of your brother's claims. So if there was an allegation of the relationship came to an end because of abuse, then, that's a reason why it came to an end. But if that's not an accusation, I would have thought 50 years on, your claims on his generosity would be fairly limited.
Maddie, given that he has been estranged from you all your life, or the majority of your life, why would you want his money?
Well, it'd be just a nice little nest egg for my brothers especially.
But Maddie, it's a basis. The claim is obligation, is essentially needs based.
So they need to demonstrate that they need this money, that
that they're not able. That there's something missing in their life as a result. So that's the basis of which they make the claim.
Okay, so you have to sort of put an argument together.
Yes.
That because he went south.
He should have left me something because.
Okay, all right. Well, Maddie, see if you'd like to make that argument. Good luck to you. Kylie in Pakenham. Kylie, how can we help?
Oh, hi. My son has signed a contract for the purchase of a block of land with a developer. And that was back in August last year. He's paid his deposit, he's signed. That title was meant to be released in February this year, obviously because of what's happening in the construction industry and COVID, etc. It's been pushed back and pushed back and pushed back. There's still no, I suppose, title release date. And the issue that he is now facing, as well as other people within the development, is that now that interest rates are going up, the borrowing capacity that they originally had, which would have allowed them to go ahead with the purchase of the property, is now being diminished, and that's now at risk of being able to follow through with the sale of the property.
Yes, understood entirely.
We're just wondering what he's wanting the land, like the property, but we're just wondering what his legal recourse could be if he comes to a situation that his borrowing capacity is not enough, given that the developer has delayed and delayed and delayed and now created this situation.
Kylie, the essence is in the documents. Now, under the Sale of Land Act, there is a concept called the development period. So the assumption is that the plan of subdivision will be registered within 18 months of the date you sign the contract, or such other period as is specified in the contract. So if your contract says, and I see them where the approval date is 3 years and 4 years, so it may, and then the next thing you need to do is look and see whether the contract's conditional on finance. Now, normally, a bank won't approve finance until they've inspected the land. So you need to see when the plan approval is, and if it's the standard 18 months, then it will be February next year, February 23. And if it's not that, then it will, and then you need to look at the finance. All depends on what your document says, Kylie.
Kylie, there's a rather unpleasant echo on the line, so we won't be able to go back to you, but I hope that's helpful. So sorry if we have to cut this one short with you, but thanks so much for calling in. Jacob in Lang Lang. Jacob, how can we help?
Hey, how's it going?
Good.
Just a quick one. I got scammed by someone last year in regards to painting some earth moving machinery I've got. They come from Sydney. I'm obviously in Lang Lang, Victoria. He sent me an invoice. I got him an invoice and sent him the deposit with the work. On the invoice had his ABN and everything. I checked that on the ABN lookup website. The ABN came up with the details that he said with his business name and location. And
have they failed? Have they, Jacob? Have they not painted or not painted properly?
Yeah, it didn't turn up. I was in contact with him for a couple of weeks after sending the deposit, but haven't been able to contact him since.
And how much did you pay, Jacob?
I think it was. Parents sent some, and I sent some. I think it was about 3,000 or 4,000 all up.
I hate to tell you that you'll need to. This isn't a VCAT dispute because the defendant would be interstate. It's a magistrate's court matter, and it's just going to cost you money. And there's no guarantee you're going to get a cracker back at the end of the day.
How much have you spent, Jacob?
Yeah, I think it was roughly $3,000 to $4,000.
And what was your overall quote?
I can't remember that
roughly
off the top of my head.
But more than that.
Yeah. Whether it was 9.
Jacob, my problem is I can't see that you'll ever get any money back. Do you have his address or just his ABN?
Part of his licence. I'll get him to send me that. So
Well, you could go and see a solicitor, or you could do a summons yourself in the magistrates' court. I just see that you're going to be putting more money after the loss that you've already suffered. Because I can't see that if this matter goes to trial or goes to a hearing and you get a judgment and you transfer the judgment to New South Wales and you pay the sheriff in New South Wales to enforce the judgment, you could be spending at least another $1,500 out of your pocket.
You're well ahead of $3,000.
And no closer to actually getting any money back.
yeah, righto.
So are you saying this one just has to be chalked up to do differently next time?
No, it depends upon Jacob's responses to the lesson he wants for himself or for other people.
What do you mean?
Is that he could simply say, I'm going to pursue this, I'm prepared to put some more money in, but he needs to recognise his prospects of getting it back are remarkably limited. You might also consider talking to Consumer Affairs in New South Wales, so they may have some kind of register of complaints.
Okay. How do you feel about pursuing it, Jacob?
I'm not sure. I might tee up that Consumer Affairs in New South Wales first and see if they've got anything. And then, it might be a case of, it's gone, and there's, like I said, no point wasting more money if the chances of getting it back aren't very good.
That's right. Let's see if we can just slip in one more before we wrap up for today. Andrew in Mount Dandenong. Andrew, if you can be brief, go ahead. Good morning.
A large tree fell on a wire outside our house and severed the power line into the house. SP Ausnet came and repaired it. It's not our tree, not our problem. They refused to send the bill to the council and have had it added to our AGL retailer's bill. Is there anything that I can do to get SP Ausnet to send the bill to the responsible authority?
So this is a tree on the nature strip?
Yep, other side of the road, David.
Okay. Listen, next week I'll look at see what the responsibility is. I tend to think that unless they knew that something was wrong with the tree, it's the council won't have to pay, but I'll take it on notice and I'll come back to you.
All right, so that's some homework for next week. David, great to see you.
Thank you.
David Whiting there, Melbourne solicitor.